can't go back, why don't we just ask them to tell us whether or not they have discharged the responsibility that we asked them, that they accepted as a result of the first hearing? Yes or no? Have you discharged that responsibility to be responsible for the counterclaim fees? And then if they decide not to respond to that or to somehow challenge that, then deal with it as it comes up. But it seems to me that there ought to be some rational conversation that would resolve this without having to get into a legal debate about whether or not attorney-client privilege attaches in this situation or not, and we wind up spending a bunch of money and time over an issue that seems rather silly, frankly.
Here's an idea, and it may not be a complete idea, but the individuals now in this matter are represented by Mr. Turner. What if we ask Mr. Turner, I mean, I don't know that we can go to them individually at this point.
They're represented by counsel.
Right.
That's right.
Right. So I think any contact we have with them on behalf of the commission has to go through Mr. Turner. Maybe what we do is ask Mr. Turner to ask his clients or discuss with his clients, responding to us in the way you're talking about, and responding by the time we get back together in a couple, 3 weeks, whatever that period is. And see what happens. I mean, John may object the same as he did at the hearing, that it's attorney-client privilege, you know, but we don't know unless we ask.
Madam Chairman,
Yes.
Chairwoman,
Yes.
Madam Chair.
Yes.
Would it be appropriate, since Mr. Turner is sitting here, to ask him if he has any preliminary thoughts on that?
I'm open to it.
The only comment I was making, I'm happy to address any question that's asked of me with clients, but the only thing I would ask is that any question be very specific in this regard. I'm looking at the signed finding from the August hearing, and what those findings say in paragraph 20 is that there was evidence adduced that a credit of $1,012.50 was given by the Working Law Group. It goes on to say, if in fact that sum represents the amount expended by the county for the services to the Working Law Group to prepare and prosecute the counterclaim, then credit of those funds is, in our opinion, this is the signed document, is in our opinion an adequate remedy. However, that credit does not address work to be done in the future. So, you know, there was, at the hearing that we had, evidence that that credit was given. And so that we came to that hearing being guided by these previous findings. And so there was a finding that, in the opinion of this group, if the credit was given, an adequate remedy had taken place. And then it goes on to say, any future buildings will be for the responsibility of the members, which would presuppose a bill has been sent to them by Working. For instance, up in these preceding paragraphs, it points out that it doesn't appear that the bills that were sent to the county that reference the counterclaim were ever seen by the legislators, and that they didn't even know that those bills were being submitted. And so Working did in fact give the credit. I don't know that there's any dispute about that. If he didn't, certainly I don't know about it, but if he didn't, and that's wrong, because you said he should, and he said he did. But if he's given the credit and that's been deemed to be an adequate remedy, I would want to know specifically what, you know, then presupposably Working's given the credit. Then I'm hearing the question then is, okay, Working should have billed them $1,012.50 and they should have paid it. But I believe that if Working thought that it was inappropriate on his own behalf to have not run that by people before he incurred the expense, and chooses not to bill them because as an attorney he didn't have a clear understanding of that with his clients, then I don't know how. It's kind of like you're saying, Working, you must bill them, they must pay you the $112, and if a lawyer is guided by his own ethical considerations, feels that, I mean, I think it presupposes he has to bill them. If he feels that I didn't clearly communicate with them that this was going to be bills sent to them and it's my bad, then I don't know why. I think he has to you're now saying you need to pay a private thing that you owe Working, and if Working said, I feel bad about this way this went down, I don't really want it, then you're saying you gotta pay it. But this says that the credit to the county is a adequate remedy because the county's not been deprived of its funds. So I'll answer any question, but I would appreciate being specific. Did Working send a bill for $1,012.50 evenly divided, and did you pay it? And I don't know if you did or not, quite honestly.
The question is larger than that, because clearly subsequent to this hearing, additional work was done on the counterclaim, and according to Working's testimony and Urbanus's testimony, bills were sent for that, which would leave this issue aside. You may have a point with regards to whether or not Working had adequately gotten the consent of his clients to do that work for which they were going to become obligated. That's an issue that I think is separate. There's no dispute, however, but that there was work done subsequent to this that was billed to the clients. And at bare minimum, leaving your point aside just for the point of this discussion right now, the question is, did they discharge their responsibility with regards to those payments that Urbanus made?
Okay, and my memory of the evidence is different than yours. I thought the testimony was that the counterclaim was a contingent counterclaim which would only become a potential to even pursue or work on once the underlying case was dismissed. I did not think that Working gave any testimony that he has been working on the counterclaim, and at least I don't have a memory of that.
Oh yeah, he did. I'm pretty sure he
He was
did.
working on the counterclaim?
Absolutely, and in fact, there's billing to support that he worked on the counterclaim. So, yeah, there's clearly work that was done on the counterclaim. The questions before us now is, did the legislators pay for that billing? Again, leaving aside your point, which may have some validity, leaving aside that point, did they pay for the work that was done subsequent to this? And two, was all the work that was done on the counterclaim included in those billings? Those are really probably the two main issues that we have to grapple with.
But did they get a bill from Working, and did they pay it?
Right, right. And I believe that there was even dates mentioned on what those buildings were, and I'm not sure if I've got them all down, but I think that Urbanus testified that there was bill 1106, 107, and 707 bills that he received. But again, the transcript will be clearer than my memory. But assuming that that information is correct, it's logical to assume that if he got those billings, all the legislators got the same billings. And if they all got the same billings, then the question is, did they discharge their responsibility with regards to those billings and being responsible for those fees? That's the main thing that we need to know. And John, and I'm just going to ask you, because it makes more sense to me to be direct. We need to resolve this question at some point and some level, and I understand all the issues that are confronting you as their lawyer, and you don't need to comment on anything, or the legislators themselves, but we're going to have to resolve this issue. Seems to me that the easiest, best, most effective way is to simply ask the question, did you discharge the responsibility? Yes, I did. No, I didn't, but I plan to. No, I don't, and I have absolutely no plans to. Whatever the answer is, we need to get an answer one way or the other. Once we get that, I think we can move on to other issues. But until then, we're going to be stuck with it.
Okay, I'm happy to field the question and talk to the clients. The only thing I would say is, to the extent that there's some sense that I, on behalf of the legislators, was trying to obstruct the information.
Oh, no.
I thought that this order was pretty clear. I interpreted the order the way you have described it. Namely, there's a responsibility, the method, which it says right here, the method of that discharge is between them. It's a private matter over which this board has no jurisdiction. And that was what we came to the hearing believing was what was going to be the framework of the discussion.
Right. No, there's nobody here that thinks that you or anyone else was trying to obscure or do anything untowards with regards to that. That's not an issue at all, so you can rest assured of that.
Please.
We're just trying to get to the core.
Did Working send a bill and was it paid?
Yeah.
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 I think that's the question we had for the hearing, like. that we had.
That's what we're trying to get at.
It's a question we've had for
Months.
very months.
For those that appeared to be asked that question.
Now,
Well, that was, but.
you've indicated, Mr. Turner, you'd be happy to field the question and ask the clients.